में लगा देंगे, ये कैमरा का प्रॉब्लम है। और ये वाला कैमरा नेक्स्ट मीटिंग के लिए चेक करना का बंद करो।
इधर से म्यूट है आपका
दो मीटिंग एक जगह से ज्वाइन है, दो
ज्वाइन करेगा।
അത് ഇന്നലെ ഇതും ഭയങ്കര പ്രശ്നമെന്നാ പറഞ്ഞ പുറത്തിറങ്ങാൻ പറ്റും. ये
Very good morning to all of you. Today we are gathered here for the celebration of World Intellectual Property Day 2025. Actually, it is supposed to be celebrated on 26th April, on every 26th April. Due to various programs in all the ICR institutes, the rest of the institutes also, along with us, today is the last date to celebrate this World Intellectual Property Day. This is actually a unique opportunity, we can say, because for sharing any advances, of the IPRs, because every awareness program we are talking about what are IPRs and how to go about it, filing everything. But every year celebration of this intellectual property day is essential because we should know how the intellectual property helps and enables the technological innovations to progress in our Indian economy. So that's the reason why we are celebrating every year. This is like a campaign type because this is highlight the role and the play out the IPRs like patent, copyrights, trademarks, and other design patents, everything, how they are playing role in encouraging the innovation and creativity. Even as far as our institute is concerned, though it is very continuous progress in the filing of IPRs, this is our proud moment for our institute also because our portfolio has been significantly increased with enrichment, I can say, with 10 granted patents last 3 years. Within 3 years, it's a very great significant achievement. And also we have got 9 animal plant genetic germplasm registered and 11 technologies have been commercialized so far. And also 6 ICR certified technologies we have got and 1 trademark in the name of deep. It is a very unique in the name of the deep we have got the trademark. So we export all the technologies that has been generated out of the ICAR-CIARI with the tag as a deep technologies. And moreover, we are waiting for 10 more technologies to be granted, including all design patents and also 5 trademarks and 3 copyrights. So this is a very good achievement. We are really, really thankful and indebted to our director because through his critical suggestions and guidance, he has laid down the progressive pathway for further progress of our institute development of the IP portfolio. Thank you very much, sir. So with this welcome note, today not only this our ICAR-CIARI staffs, we have with us the project staffs from ICMR also and NIOT also and even from Lakshadweep because that time last because we conducted some national innovation awareness mission program also. So under that program, many students from the this one Lakshadweep also they joined. So today as soon as I send the flyer, they are very much ready to join for this program because this program will address on the artificial intelligence versus innovation. So that will be a very hot topic. So with this welcome note, I invite our director to give us the introductory remarks.
Madam is joined. Good morning, friends. Wish you all the IPR day. I think everybody agree that we have got intellectual. Nobody will tell I am not intellectual. Everybody is intellectual. But we should know our property, what property we have got. Not in physical mode, but intellectual property. And it is your right. So, to fight for that intellectual IPR, proper right, world is celebrating this day and week. But I feel when we do any work intellectually, That's why I always tell you, we should work like horse, not like donkey. Both carry the weight, but horse is respected more because he does work smartly. So whatever you are delivering, it is smartly delivered. And then you claim, yes, it is due to me. That is the way you can tell it is my contribution, this intellectual property right. My means when I'm part of an institute, yes, it is institute property or organized property, ICAR or government of India. So whenever we do, when we think of the IPR, automatically we have to think from all the direction. Its market potential, really whether it will change. Because if I create a technology and nobody is taker for that, then my technology has no meaning. Finally, we develop all the technology for the ease and improving the lifestyle or livelihood of the public. I'm really happy our institute being a small institute. Now we are progressing very satisfactorily. Almost all the points of the IPR we have touched. But again, I urge all of you, request all of you, whenever you make any project or apply for any external funded project, keep in mind what is expected output. That expected output should also be in the form of IPR. So that will give credit to you and it will give identity to you. Particularly, we get identity. Money is not important how much you are getting out of that by sale of technology or something. But we consider, yes, that technology has got strength. That's why somebody is ready to pay and take that technology. So from that angle, you always think. And sometimes if we feel really it's a good technology, but this is more useful for the society, organization things, then with low cost, we can make it for public. But anything even free is not respected. So we should first claim our intellectual property right, then we can think of. So all the best, and let us listen from the both experts what Sujata madam has organized today. Take the message from both of the experts. Thank you very much.
Thank you very much, sir. Nitin, ma'am, have you joined now, ma'am?
I have joined, Dr. Sujata, I have joined.
Thank you very much, ma'am. Today we have actually renowned resource person, Dr. Nitin Tiwari. She is a senior principal scientist and head of IPR division of CSIR National Chemical Laboratory, Pune. She is a registered Indian patent agent too. Congratulations, ma'am. Actually, they have got the best IP portfolio of NCL that December 2024. Under your really the hard work and dedication, ma'am. Congratulations again. She is actually very well known personality to ICAR. Today also she is participating in a series of lectures in the whole ICAR institutes. And welcome you, ma'am. Without wasting much time because you have to join some other program also, I invite you to give a talk on the technology, the patenting of biotech inventions, history and future. Yes, ma'am. Welcome, ma'am.
Thank you so much, Dr. Sujata. Can you hear me?
Yes, ma'am.
Perfect. And a very good morning to all of you in the audience. It's a really pleasure to have you all on this occasion of the celebration of World IP Week. I really appreciate the efforts of director of the institute and also Dr. Sujata and nearby institutes like NIOT, etc., who have joined. That you all have arranged this and you have found time to attend this event, realizing the importance of intellectual property. And separately, I understand that the institute CIARI has been involved also in couple of patents, trademarks and tech transfer, which is quite commendable. And a salute to all of you working in I would say not so easy conditions there, but yes, you all are doing a great job and I congratulate to all of you. And that is why I particularly wanted to join the CIARI talk, especially because that is my way of appreciating your great work you all have been doing, and the leadership, of course, the director. I think you have set the tone right, that we should work like horses, not donkeys, because it is the brain which differentiates the two. That should be one of the key takeaways from this. And Dr. Sujata, I very much look forward to the deliberations of today's meeting, wherein you have decided to talk about AI as well. So a very good topic, which has a lot of avenues, lot of interpretations, perspectives, and I think with our researchers understanding the details, it would be very very nice, so that they can use AI just like horses to help them in their work and not be their substitutions in any way. So coming to my presentation, can you all see my slides?
Yes, ma'am, we can see.
My slides are visible. Perfect. I somehow cannot see that. What? Okay, just let me see. Yeah, now I can see. So my slides are visible. Perfect. And this is the first slide, but I will start with a video to make you all understand like what is the importance of. Yeah. So
Yes, yes. We will all of it. Yeah. Yes, yes. It's not audible. It's not audible.
Ma'am, your voice is not audible, ma'am.
okay. So basically, the idea of this particular I will go back to, yeah. So the idea of these two videos was, I think, if you all have understood, am I audible now?
Ma'am, can you please repeat the video? It was not visible for us.
So sorry, so sorry. Just one sec, please. I will do that.
Okay.
Yes, ma'am.
Reload it. That
You can again reshow it.
Whether to share both the whole screen, not only presentation.
Ma'am, you can share the whole screen, ma'am.
Not presentation.
Okay. What I suggest is, did you see the first video?
No, ma'am. No.
That was the crux. Okay, just wait. I'll try once again. I'll share the entire screen.
Mm.
Now, is the video visible, Doctor?
No, ma'am. No. We go to the video side, then we can share, ma'am.
Yes. Just one sec. So sorry.
she's thinking she was.
Can you see that now?
अगर मुझे आपकी हेल्प हो गई तो मैं
Audio?
एक नंबर चीज
पर
बनाऊंगा।
कोई कॉपी कर लेगा ना, ये कॉपी कर लेगा ये।
हाँ सर, मुझे मतलब पेटेंट के लिए मुझे किसी ने हेल्प नहीं किया सर।
कमलेश, मैं दो बात करूं, आपकी हेल्प
हाँ।
ट्राई करता हूं करने की। हम जब बैठते हैं, देखते हैं यहाँ वहाँ, तो हमेशा कंप्लेन करते हैं हमारे देश के बारे में कि इंडिया में ये गलत है, भारत में ये गलत है। आपको देखकर एक बार फिर से विश्वास जाग गया कि जो 2020 से 2030 की सदी है ना, इंडियन एंटरप्रेन्योर्स की है। जैसे इंडियन इंजीनियर्स और डॉक्टर छा गए दुनिया में, वैसे इंडियन एंटरप्रेन्योर्स की सदी, और खाली बिग टाउन की नहीं है, ये आप जैसे किसानों की भी सदी है। तो बहुत अच्छा लगा, बड़ा विश्वास पैदा हुआ।
थैंक यू सर।
लेकिन जिस स्टेज पे आप हैं ना, ये आविष्कार के लिए आपको फंडिंग मिलना मुश्किल है, क्योंकि आज तक आपने एक भी नहीं बेचा। लेकिन निराश
चीज चाहिए थी मेरी रेडी नहीं थी, तो मैं किसानों को सकते शायद 20 लीटर का जो टंकी था मैंने इस पे रख दिया और पीठ पे लेके हम स्प्रे करते हैं, तो वही स्प्रे हम ऐसे करेंगे।
Can you see the video, the design?
बहुत अच्छा,
बहुत बढ़िया।
इनोवेशन।
शायद मैंने ये डिजाइन खुद किया है। बहुत सारी कंपनियां हैं, बहुत बड़े बड़े प्रोडक्ट है, कोई ड्रोन बना रहा है, ड्रोन से स्प्रे कर रहा है, बट अपने भारत देश में 70% किसान है, उसमें से 50% है वो छोटे किसान है। तो मैम छोटे किसान ले सकता है क्या ड्रोन? छोटे किसान को छोटी चीज चाहिए ना, तो मैंने ये चीज बनाई। इसे बनाने में मुझे 7 साल लग गए मैम। मुझे लगता था कि इसमें कुछ चेंज करूं, तो मैं चेंज कर देता था, और बाद में ऐसे करते 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 ये मेरा फाइनल डिजाइन ये आया। और शायद ये मल्टीपर्पज है, मतलब ये 2 या 3 काम कर सकता है। लगते शायद 20 लीटर का जो टंकी था मैंने इस पे रख दिया और पीठ पे ले।
So the idea of these two videos is to highlight the main issues in the agriculture ecosystem, in agri-tech ecosystem. One, that the technology is not useful until you have made it to commercialization. So as director said, also said, it is not the quantum which matters, but it is the impact which your invention makes. So another thing is, the fellow says that in spite of 75% being agricultural, still the solutions are not affordable, and there was no
Slide, ma'am. Sorry.
Sorry.
Are you sharing your slide because it's not visible?
Yeah. Started with it. Okay. Can you see that, Dr. Sujata?
Yes, ma'am.
Yes.
Yeah. So this particular video highlights these aspects, that that there is not enough help available at all the stages of all the at all the levels of society. So it is our duty as researchers, as mentors in the startup and the IP ecosystem, that our help reaches all, and all as like would have been in the best place possible. So coming to back to the topic precisely, so I have decided to cover the agri-tech aspects of IP and how we can protect that. So I think already CIARI is doing a very good job in terms of trademark, patents, etc. So this is just a reflection as to how you can look at inter-collaborations, inter-institutional and intra-institutional as well. So major application areas in biotech, and because it is like the ocean and the island research, I will mostly talk about the blue biotechnology here. So major application areas are into health and diagnostics, the red biotech, agriculture, about the production with high yield and quality. So this covers both the blue and the green biotech. Then bio-based process for reducing pollution, CO2 emission, global warmings, and alternate energy, to counter the effects of fossil fuels, etc., and provide corn, sugarcane, cellulose, etc., for newer options as of fuels. So this is one chronology of the biotech patents to let you understand how far we have come. So the first patent in biotech was, and this is like the traditional biotech I'm talking about, was in 1911. This was regarding the adrenaline through extraction. There was no genetic engineering involved. Then in 1973, the recombinant DNA technology came up with the Cohen and Boyes method, and there was a patent in 1980. 1981, this is a very, very critical patent granted in 1981 about microorganisms having multiple compatible degradative energy generating plasmids and preparation thereof. So this is a landmark case in history of patents, because this is the famous Diamond versus Chakrabarti case, which established that organisms existing in nature as such cannot be patented. But just like in this invention, wherein pseudomonas had been genetically engineered, introducing a gene which could absorb the oil spill locally in the area wherever it was produced, very important for marine engineers, etc. So such microorganisms can be patented. 1982 saw the first patented
Ma'am,
Yes.
your slide is moving, ma'am. You are moving on to next slide.
So I am okay. But one sec. There is some issue.
Yes, ma'am. Ma'am, you can
I will reshare. So, anyways, I will keep talking in interest of time. So, can you see the slides now moving?
No, ma'am.
Okay, I'll just reshare. So another, then in 1988 was the Howard Oncomouse patent which was granted. So this Howard Oncomouse again established that plants and animals per se cannot be patented until you have changed something. But in any case, even if you have genetically modified, now can you see the chronology of biotech patents?
Yes, ma'am, it's visible.
Okay, so 1988 was Howard Oncomouse. Interestingly, for the students in the audience, this particular Howard Oncomouse, the word Oncomouse is a trademark in the US. Was a trademark in US Patent Trademark Office. There were a couple of patents around the cell lines, the progeny, the entire mouse, and which were later recalled because it was said that the animals per se cannot be patented. One second thing is the progeny, which was produced automatically, even if the altered gene was inserted into it, cannot be claimed because they were reproducing by a natural process. Then in 1991 we saw like the patents around stem cells. These are some of the bioproducts which are available through the using the biotechnology, like vitamin B2, then amino acids, ascorbic acid, acrylamide, fatty acids, PLAs, methanol. So all these are big companies operating in the space. Then we come to how can we protect the biotech related inventions. So we all know, we all talk about mostly patents, though there are other aspects, but again we will delve more on this particular topic of patents. So patentability, any product process which has some technological intervention can be patented. And summarily, I call this patentability criteria as NUNS test, NUNSS, wherein first N is for novelty. That means the work you have done is hitherto unknown, not known, not used, not sold by anybody. Then another U is for utility, wherein your work should have a real world application. And for publicly funded research lab, this utility has to be an impact on stakeholders as well. Then is non-obviousness. Non-obviousness means your work is not an obvious extension of the existing prior art. So I give a very simple example here, that you did some reaction with sodium and then you substituted with potassium, saying that this is a novel work. So your work may be novel, but it will not be obvious, because any person who understands little bit of chemistry will say that these are same group elements, so they are supposed to behave in a similar manner chemically. So this is an obvious alteration of the work you have done. Then first S stands for statutory patentable invention, meaning that your work does not fall in the non-patentable category of that particular jurisdiction wherever you have applied for patent. Then so there are various segregations across the world, wherein they like major economies like US, Europe, India, Japan, they have listed as certain product and processes as not patentable, while others as patentable. I will talk about that, and this is very very specific of the countries, and we cannot argue upon that if they have listed something in the non-patentable invention category. Then last S is for sufficiently disclosed in the specification, meaning that your work has the patent application which you send to patent office should have sufficient details of your work, so that anybody who wants to replicate your work can do it without undue experimentations. So now this is about the inventions which can be patented, like in biotechnology, which is polynucleotide gene sequences, constructs or cassettes of gene libraries, provided you have indicated a use to it. Polypeptide or protein sequences, vectors like plasmids, phage vectors, host cells, recombinant microorganisms, transgenic cells. The process can be patented. Plants and animals tissue culture processes, then pharmaceutical vaccine compositions comprising microorganisms, proteins, polynucleotides, antibodies, antigens, diagnostic kits can be patented. Then we come to the list of non-patentable inventions, which I think most of you are aware of. Discovery of living things occurring in nature. So in case you come across, like you sort of isolate certain bacteria from the coast, and you want to patent a consortium of those bacteria which is supposed to perform a certain task. So in that case, you cannot patent them as such, because you have just taken the bacteria out of their natural environment. You have not done anything, any technical change into that, so that cannot be patented. Then plant animals as whole, then seeds, species, varieties, and primarily the biological processes to reproduce that cannot be patented. Human beings, embryonic stem cells, genetically modified multicellular organisms like plants, animals as whole, method of medical treatment. So this list is more or less same for both India and Europe. However, in US there is a difference, because they allow method of medical treatments, they allow patents of plants as well. So these are some examples based on the domain of the institute, wherein you all must be noticing working around the ocean and the related agriculture stuff. So this is one of the patents which was granted, so this is automated open fish farm structures and system for open ocean fish farming. So if you look at the claims, so they claim a system for growing aquatic resources to be maintained in approximate geostationary position, including relative to the water surface, comprising and these steps. And this is the system for growing aquatic resources here, right? So these are some of the patents which can be granted in the area of your research. Then there are certain other areas like the seaweed and algae cultivation patents. So we all understand that seaweed is a focus right now because of its applications in food, biofuels, bioplastic. So there can be systems and method for large scale seed cultivation, automated seaweed farming apparatus using drones for monitoring and harvesting, method for producing biofuel from algae. And I think the CIARI has been involved in a tech transfer related to vertical farming as well. Recently, I read about that. So that is also one of the things you can look at. Then offshore and floating farm patents as well. So wherein there are floating structures to grow crops in because the land is limited. So in that case, the examples could be modular floating aquaculture systems for deep water farming, offshore vertical farming system using wave energy for irrigation, floating marine permaculture platform integrating fish, shellfish, and seaweed. And similarly, there are marine biotechnology patents also using CRISPR-Cas, wherein the gene editing has been done in algae for increasing their productivity, for carbon capture. And then there are aquaculture or hydroponics related patents as well. So recirculating aquaculture system for offshore fish farming, AI driven monitoring system for reducing pollution in shrimp farms, and ocean fertilization and carbon sequestration patents also are there. So these are some of the varieties wherein you can look, like these types of claims can be looked at. So one landmark case I would like to talk about. This is from agri-tech, but similarly, you can think of similar situations in case of algae, in other natural organisms you might be working in. So here, so Monsanto, you all might have heard, was working on the soybean crops, and they were around capturing 80% of the market at that point of time. So they genetically modified the soybean crops to make it glyphosate resistant. And there was a herbicide which was called Roundup, and that used to kill everything else but not the soybean crops, obviously, because they were modified to be resistant. So but eventually what was found out that the resistant crops were sort of crossbreeding with other crops in the non-natural crops in the nearby area, which was intermixing and causing the issues. One second thing is Roundup was found to be cancer causing, and therefore Monsanto had to give a lot of compensation to the people around, the farmers around. And then Monsanto came up with maize, with cotton, BT cotton, you might have heard of. Then similarly, you have updated soybeans as well, wherein the soybean crops which had turned resistant to glyphosate. Now they were modified to become next generation, wherein they had both glyphosate resistant also and dicamba oxygenase resistance as well. So the DMO gene was used to make the soybean crops, cotton systems as resistant to these two as well, which were otherwise used as herbicide. But the same issue was here, that they were carcinogenic. Now coming to trademarks. So apart from patents, trademarks can also be used to protect IP. So if you look at the startup ecosystem of the country, there are around 35 to 40% of agri-tech companies in play. So this cropping is an agri-tech company. Then we also see in our there are distribution channels which have been created, and they ensure that the produce which we get is farm fresh, something like Agribolo. Then there are Kisan Connect also. So all these are using their trademarks. And in any case, if any of the students in the audience wishes to be an entrepreneur, and any scientist also wishes to be an entrepreneur, trademark is one of the first things you should patent when you feel that. Trademark is the first thing you should be protecting if you feel that your invention is picking up and somebody else might capture on your market. So first thing is that you please protect your trademark, and if you are not formally until you have formally done that, you can always use that TM logo and encircle TM. And by the time you get the protected trademark, you can use this registered trademark logo. And just wanted to update you, this NCL Innovations is the trademark of NCL. And idea was that with any tech transfer, we would use this particular logo to indicate that these are solutions from CSIR India. So that is one way of branding your stuff as well. So this is critical to understand. Trademarks can play a very, very vital role in protecting your IP apart from patents. And coming to geographical indicators, so we all know that things which have a particular unique taste, flavor, because of the abiotic climate and conditions in a particular area, they give them a particular unique property, I would say. And if the article is man-made, then in that case there is a certain art which has been transferred over the period of time to people locally who produce that. So like in Andaman and Nicobar, we have Nicobarese hut, and there are a lot of shell arts also happening. So all these are GIs. And other famous GIs which you all might have heard of are like Mahabaleshwar strawberries, then there is Banarsi saris, then there are a couple of handlooms, then even brinjals of Banaras are GI protected. So this is the criticality of GI. And obviously, just like we anticipate other forms of IP, GI is also supposed to improve the economy of the particular area locally. So this is one example of Devgad Alfonso mangoes. So Alfonso mangoes are basically cultivated in the 700-kilometer Konkan region of Western India, and they have a lot of export value, and they have a very unique taste and flavor. And within that Alfonso, there is Devgad Alfonso, which has a particular very attractive shelf life, very attractive yellow color, long shelf life, low fiber, which makes it very suitable for export. So our technology business incubator filed a GI application on behalf of the farmers of the Devgad Alfonso mangoes. And interestingly, the biochemical sciences division of NCL was replicating the gene sequences which were identifying and replicating the gene sequences which contributed to the unique taste and flavor of the Devgad mangoes. So we found those gene sequences, and the idea was that we will use those to produce the color, taste artificially, and which would be used in the confectionery. So this particular GI application had our genetic sequences also appended it with it. So that is a very important thing to understand, that you may have certain plants on and plants which may have certain unique properties, which can be identified and substantiated using the gene sequences, which can stand out as a GI for your particular area as well. So these are some of the other GIs which are very famous, like Kashmir saffron. We know the commercial value of Kashmir saffron. Coorg oranges, there are Nagpur oranges, there are Arunachal Pradesh oranges as well. There is Shahi Lychee of Bihar. So there are like India is full of such GIs, and similarly, other organizations can identify things nearby and protect the GIs. Government is promoting GIs a lot. Then is the another form of IP which can be protected in agri biotech is the industrial design. So you may change, you may alter some sort of some existing device to make it more useful, make it more attractive. Maybe you make it more sophisticated to handle. So you can always protect that under the industrial designs as well. And just like the video we saw, so that is also a design which has been created, and the life of design would be 10 years and can be renewed for another 5 years. So there are a couple of startups these days existing in the agri-biotech space, and this is one example of Fasal, which is in the area of which integrates the IoT and the precision farming app based, helping the farmers to understand the techniques of right way of farming, which crops, what is the temperature condition which should be maintained, and what is the value chain. All these things can be accessed by the farmers at one click. Similarly, there are drones, there are other devices like this Fasal Kranti we see here, which has been granted a patent. So this is a solar powered IoT device for precision farming, which senses the things around and gives messages that okay, this particular thing is not in order. So such things are like a lot much into inventions right now. So another way you can protect your inventions related to agri-biotech is also plant variety. So because in India plants cannot be patented, but in case you have changed anything, any plant variety to improve its say yield or improve its oil content, you can always protect the plant variety. As such, the process can be protected under patents. So as we learned in patents, the criteria is nonce test. In plant variety, the criteria is DUS. So D stands for distinctness. Use, that means your product is distinct over the existing plant variety. Use for uniformity, that means whatever changes you have made are uniform. And then is stability, changes you made do not die over one generation only, but they continue further as well. And these are certain certificates which have been issued in 2023 until 2023. So like 3,000, more than 3,500 are cereals, 538 fiber crops, vegetables, oil seeds, spices, trees, forest, plantation crops, medicinal aromatic plants. So there is a huge list of that. So if we see, there was a huge surge in 2014 about these varieties which have been protected under Plant Variety Act. And another aspect wherein you can protect your inventions is also semiconductor integrated circuit layouts. In case you have developed some sensor mechanism, maybe to test say any conditions, be it a pH or presence or absence of a particular thing, then such sensors and such topography of the circuitry can also be protected under the semiconductor integrated layout circuits. So given the importance of the day, I'm not emphasizing on the process to do that, but I just want you to understand that these are the aspects by which you can probe your research work, proactively thinking that okay, you can protect in this way, and there can be multiple ways as well. It is not that only one IP can be protected, and it can be a long term thing, but it can be a long term protection because a patent has a life of 20 years from the first filing. Then similarly, design can have 10 plus 5 years. But if you want to protect for a long term, if you have a strategy, you can use these all these forms of ID in a very very strategic manners, just like companies do that. So that is it from my side, and I have pushed my email ID and my LinkedIn profile. You can connect with me, and in case you wish to know anything more about any detail, I will be happy to answer you via email and also today in this audience. So over to you, Dr. Sujata.
Yes, ma'am. Ma'am, first of all, thank you very much, ma'am, for your very, very comprehensive and very fruitful presentation. And particularly, you have presented with all case studies that are appropriate to our island climatic condition and also to the carry. Especially this, all the patents with in fisheries sector, that is aquaculture and marine farming and more, many things you have pointed out, ma'am. You have opened the area where we can go for the patenting, and also, it's very good, useful for us how that the GI tags for the varieties. Not only we cannot go for the variety registration, but still we can go for the process. That is a unique process present in a particular variety. Then we can go for any patenting. So thank you very much, ma'am. And also you have given the strategic protection on multiple ways of protection. How we can go for that, and mostly you are in between. I am taking your guidance also, but still it will continue for our further progress of our IP protection. Thank you very much, ma'am. And you are, I think, urgent in going for online other meeting.
Yes.
Thank. Yes, ma'am. Ma'am, I request other audience who are online, if you have any queries or doubt, just one or two questions. Otherwise, you can write to us, then we can revert back to you.
So Dr. Sujata, in case there are one or two questions, I'll be happy to take.
Yes,
That
ma'am.
is not
Yes.
an issue. So you let me know.
Even yeah, online people, if anybody, students have joined from ICMR and NIOT, if you have any questions, you can ask, ma'am. Otherwise, from our carry side also, yes. Anybody? Okay, ma'am. Thank you very much, ma'am. Anyhow, we will write to you, ma'am, if anything we have any doubt or clarification.
Sure. Thank you so much, Dr. Sujata and your team. I really appreciate your hard work. Thank you so
Thank,
much.
thank you, ma'am. Thank you so much. Ma'am? Uh, Ma'am, is it that from Miss Kriti Patak, ma'am, from United and United has joined, ma'am?
Yes, yes. This is Kriti Pathak from United and United. Good morning, ma'am.
Good morning. Okay, we'll move on to next our presentations. We have two renowned persons from United and United. That is our United Patent Agent for our carry. Not only for carry, to many ICR institutes they are there. We are carry and United Patent are working together for more than 10 years for filing IPR and other processing. And we have two renowned persons like Miss Kritika Patak, Associate of United and United. She is an expert on copyright, trademark, and industrial design. And one more resource person, Dr. Shivangi Johari, patent agent and senior associate of for United and United Patent. Actually, thank you very much, ma'am, for accepting our invitation for talk on artificial intelligence versus innovation. You are expressed your enthusiasm, like that you have mentioned. Thank you very much for that. AI has been conceived to be the ruler for the future. So it will be very much useful for us also to listen to you. Welcome you, and it is over to you, ma'am. You can proceed.
Thank you so much for having me here, ma'am. It was lovely to talk to you yesterday. Also, I was talking to ma'am. Such a lovely person. I would like to take this opportunity to tell you. Very polite, very forthcoming, very polite, everything, very forthcoming. The whole institute. We have been associated with ICR from such a long time. So it's really great to be here. Okay, so the topic of today's presentation is intellectual property rights for me, as I'm an advocate and practicing intellectual property rights from past 7 years. So I want to relate intellectual property rights to trademarks and copyrights and also designs. So I have prepared a PPT. I would just like to open it on the screen. Give me a second, please. Is the screen visible to everybody?
Yes, ma'am, it is visible.
All right.
Ma'am, put in slideshow mode, ma'am.
Yes, one second. Okay. So what is basically intellectual property rights? Let's start from the very root cause. Intellectual property is something that originates from the mind of a person. Okay, it is intangible. You cannot see it. For example, it's an idea. An idea is not visible to anybody, right? But it is also a property which is recognized under the laws of which is governed by different laws. For example, trademark, we have a different law. Trademarks Act 1999. Copyrights, different law. Trade secrets, it's not a law as of yet, but the courts have recognized it as confidential information. So intellectual property is basically a legal concept that refers to creations of mind. It can be anything: inventions, literary, artistic, design, logo, image, anything that a person thinks of. You get it registered, you get your rights over it. What are the kind of intellectual property rights? Basically, if we start from the basic, it's 6 rights. Okay. First, patents, trademark, design, plant varieties, copyrights, confidential information, and if you also consider then geographical indications. So how do we understand these rights? It is a very fancy term that may seem very difficult for a few people, because the people who don't know, when I was studying in college, I was actually very baffled with this idea. What is intellectual property rights? So let's understand with the example of a car, or let's say, take this example of a pen. I have a pen in my hand. The name of this pen is Uniball. Okay, so the name is what? It's the mark that represents a trade, and hence the name trademark. Uniball, the name of this pen, is a trademark. The mechanism, the person who thought of the mechanism of using the ink in such a way, of using this pen, and let's say there's a new idea that a person comes up with, and then they think, I am going to make a pen which is going to be used very differently. Let's say the ink does not run out ever in the life. I'm just taking an example. So you can get that process patented because it is new. You have invented something, right? You take this pen, you write something on a copy, or let's say you type something on a computer. You take this idea and give it a form. What can you do? You get the rights over the copies of that particular work. What is that? That is copyright. Geographical indication, it is something that relates to particular territory of a place. For example, let's say I make a pen by using some resources that are only available in a particular geography of India, or let's say somewhere else. For example, Rasgulla, it is a geographical indication. The pedas of Mathura, a geographical indication, right? So that is the example. And what is confidential information, which is also known as trade secret? You and I do not know what Coca-Cola is using to make it taste that particular way. If it is out in the open, it does not become a trade secret. It goes out of the territory of that particular law. That is trade secret or confidential information. So trade secret is nothing else but a thing that a person thinks of. They make it, they commercialize it, but they do not tell anybody else what the formula is. That is trade secrets. Now coming on to the major topic, that is trademark. What is a trademark? As I said, a mark which represents a trade is a trademark. As simple as that, right? The pen, Uniball, it represents the trade. When you look at this pen, you're going to say, oh yes, it's a pen by Uniball, right? So it's a trademark. Now what can be a trademark? It can be word, it can be a device mark, it can be logo, it can be a shape, it can be a particular color combination also, right? There are different types of trademarks. Now this is very interesting where it gets. So there are two types, major two heads: conventional trademarks and unconventional trademarks. Okay, what are conventional trademarks? A word mark. You listen to something like, hey, I was having Amul. What do you think? I was having what? Vegetable? No. Amul brings it to the idea that we were having some kind of a milk product. It is a word. It does not necessarily have to be a logo for you and I to recognize that it is something related to what? Milk products. You say, hey, I'm wearing Nike. Now the other person is not going to think that you are wearing, let's say, a ring by the name of Nike. No, we know Nike makes shoes. That is a word. It has that kind of recognition in the market that once I say Nike, people are going to recognize that it's a shoe. Other examples can be Armani, Adidas, example, etc. Now, secondly, the second kind of conventional mark is going to be service marks. What are service marks? That is a mark that recognizes that a person is giving some kind of service to the other person, and that service is being recognized by a mark. It can be a logo, again, it can be a word mark. What is a service mark? McDonald's, it's a restaurant industry, right? When we say we are having McDonald's, we are referring to a restaurant. Restaurant is not a good. We cannot buy a restaurant. We can buy a restaurant, that is a different thing. But when we go to a restaurant, we go there for food. Now, food and drinks, beverages, these are the services that that particular restaurant is providing us. Okay, so these are service marks. McDonald's is a service mark. Walmart is a service mark. Big Bazaar is a service mark. Why? Because they are providing these kind of services to us. Now, next, collective marks. What are collective marks? Taking the example of CA, chartered accountants. You must have seen while going on roads that there are different cars that have this logo of CA and a green swoosh kind of thing going across A. Now, you can say, like, I have a trademark, I have the proprietary rights over it. Why is the other person using it? That's different with collective marks. Anybody who is a part of that community can use that mark and is the proprietor of that mark. Not just one single person. There are different persons who can be proprietor of that single mark. The example is CA, chartered accountants. Other example can be CS, company secretaries. Okay. What are unconventional marks? This is very interesting. Color marks. You see a Cadbury chocolate and let's say you don't even see the chocolate. You see the backside of a Cadbury chocolate. You see that particular purple color of that chocolate and you automatically associate that in your mind to be a Cadbury chocolate. That is a color mark. The company has a registration for it. Other people cannot use it in the same way that Cadbury is using it. What is a shape mark? People also get shapes registered. You people might remember that in the old days, these glass Coca-Cola bottles used to come, that people used to use it and leave it at the shops, then they could be reused again. That particular shape of a Coca-Cola bottle is registered under the shape marks. It comes under the trademarks Act 1999. It is actually registered. Second example can be a Zippo lighter. Once we see the shape of that lighter, we know that it belongs to that particular company. Just like with Coca-Cola, once you see that bottle of Coca-Cola, even the plastic one, you're not going to think, oh, this is Pepsi. No, Pepsi has a different shape of a bottle and Coca-Cola has a different shape of bottle. Smell marks. So you might not know this, but it's a very quick, quirky thought and a very quick fact that once you go to Taj hotels, it's a very big chain of hotels. We all know that it was bombed in Mumbai. We all came to know about that scenario. But when you enter the Taj hotel, there's a particular scent that Taj hotels use for their hotels. And you go inside it, you smell it, and that particular smell is actually registered by Taj hotels and nobody else can use that smell. Why are people doing this? They want a person to enter the hotel, they smell that particular smell, and when they go out, they want that smell to linger. Next, when they are going to enter that particular place, they are going to associate that smell. You are entering that hotel, you don't even know that you are smelling it, but you smell it, you associate that one, you go one time, you go two times, three times, that smell gets associated with that hotel, and whenever you smell it, that hotel comes to your mind. You smell that smell, Taj hotel comes to your mind. Okay, there's this bubblegum scent that has for sandals, they have it registered. So it's not just about a mark that you can get registered. It can be a shape, it can be smell, it can be color, it can be anything. Okay, you can see it on the screen. Coca-Cola bottle, the shape is registered. What is the name? Coca-Cola. That's also a trademark. M for McDonald's, that's a symbol, right? I'm loving it is slogan. You listen to something like just do it. You know we are talking about Nike, right? We have that kind of association inside our mind. Now we can also get the particular color. It's very difficult to get it registered, but since there are company that have been in existence from a very long time, for example orange, so you can also get that registered, but there's a certain kind of recognition that company needs to get that kind of registration. Now you see this W logo on the screen. We know we are talking about a car here. That is the effect, that is the power that a logo or a word or a shape holds in itself. We know we are talking about Volkswagen cars here when we see this W logo. Now, as I know, there are a lot of people associated with agriculture here. So there are different classes, first of all. In niche classification, they are called from 1 to class 45. 1 to 34 are goods, and 35 to 45 are service classes. As I said, like restaurant is a service that a person is providing. So these are the kind of classes that you people are largely going to be associated with, but that is not much of a concern to you. It comes in action when actually you go for a registration, and then the advocate is actually going to help you recognize which class you are going for. But still, it's good to know that, for example, class 44, it's for pest control services for agriculture, aquaculture, horticulture, and forestry. Now, some people might be thinking startup is in a boom in India right now. So a lot of young people are under the impression that yes, I'm going to open a startup. So how can they open a startup? They are going to think of a name, right? Maybe some people are thinking of I'm going to open a shop like 7-Eleven or a mall like Walmart. You'll have to think of a name, what to go for, what to not go for. Go for something that is easy to speak, easy to remember, and is a coined or invented word. Because if that word is already being used by somebody else, alas, it cannot get registered because the other person is already using it. What to not go for? Laudatory or descriptive words. For example, you think of opening a burger place, right? And you think that I am going to name it Perfect Burger. It can't be registered because, delicious burger. It is a laudatory word. The trademark registry is going to say, is your burger only delicious? Our McDonald's burgers are not delicious. Burger King, Burger Sing, there are new plethora of burger places available. So it can't be laudatory or descriptive. It can't be geographical name. You are going to open a Rasgulla place and you name it West Bengal Rasgulla. It can't be name of a place. Okay. Matter prohibited by law. Obviously, you can't name it something which is prohibited by law, or a matter which is, as I said, already existing in the trademark register or in the market, let's say. What are the benefits of getting a registration of trademark? One, you get it registered, you think of a unique thing. Now that particular word belongs to you. You become the proprietor of that particular word or that logo that you thought of. It is your intellectual property. Nobody else can infringe upon it. Okay, you have the exclusive right of using it. And if you find anybody else using that, then you can actually go to the courts and say, hey, this person is using my mark or my logo, anything else, and it is infringing my rights. So I have to go against it. The court is going to say, yes, you are registered under this mark. You are the proprietor of this mark. Nobody else is allowed to use this mark. Okay, so you become the owner of that particular thing. Now, what you can do with a trademark, you can assign or license it. Let's say you think of a particular coin or a unique word that is very catchy. Okay, somebody else says, that is very catchy, already have a business. I want to open a sub brand by the name of it, by the logo of it, and you assign it to me. Now you are the proprietor of that mark. You assign or license the other person. They're going to pay you some kind of money. Yes, that can also be encashed upon a mark. A trademark can also be encashed upon. It's a very fruitful thing that can be available for a person who gets it registered. And you license it, you get into a contract, monthly, yearly, whatever it is, and the other person is going to pay you royalties, these kind of things. and also the goodwill. Lastly, for example, let's say you take the example of a fashion brand, Hugo Boss. We all know what Boss is. We have seen counterfeit products roaming around in the market for Hugo Boss. You see a shirt by the name of Hugo, or let's say Boss, we know it's the clothing given by the fashion brand Hugo Boss. Now, Hugo Boss was actually a person, Hugo Ferdinand Boss, in Germany. He started the brand by his own name. Now we associate it as a brand, but it was actually Boss was the surname of a person that was born in 1930s in Germany. So that goodwill of Hugo Boss is associated to that mark, to that particular trademark. Trademark registry, once you get to register a mark, you have to go to the trademark registry. It is governed by Trademark Act 1999 and Trademark Rules 2017. Now, some trademarks that people from agriculture might be associated with. So these are some examples of trademarks that you can see on the screen right now. Watercolor trademarks, as I gave you the example already, but you see this tractor. This is a tractor of Kubota company. We see this tractor, we are already we in the mind we're already thinking of that particular company, Kubota. We look at JCB, we know that this particular yellow and black is actually associated with this company JCB. We see these sandals with red soles. We know these particular sandals belong to Christian Louboutin, the major fashion brand that everybody talks about these days. Now, when you get your trademark registered, how is the certificate going to look like? It's like this. Your Oakley is a brand of sunglasses. So the trademark registry brings up this certificate and it looks like that. Coming on to the topic of copyright. Now, as I said, you do something, you think of something, you write a research paper. Now, you get the rights on those copies. That is copyright. Simply that. Okay. It is an exclusive right over your idea that you have presented under Section 14. Different things are enumerated under Section 14. So, you have the exclusive right to do or to authorize anybody else to use that particular thing. For example, you write a novel, okay? So in that novel, you can give that novel to a publisher. You are the author, that person can be the owner. You are authorizing the other person to use it. You can get the royalties, you get into a particular kind of contract that can have plethora of n number of things in the contract that you and the publisher decide upon. But a copyright, once you are the author and the owner, you are, let's say you're not publishing it anywhere, at that particular moment you are the author, you are the owner of that particular piece of work, and you have all the rights to reproduce it, to communicate it to the public, to adapt it in any way that you want to, and to translate that work in different languages. Registration of a copyright is not necessary. You, for example, J.K. Rowling, she wrote that Harry Potter's. Once she wrote it, she did not necessarily had to get it registered under the copyright laws to get the rights over it. Once she wrote it, she communicated it to the public, she already had the rights over it. Okay. What are the benefits? Firstly, no official registration is required. You can sell or pass the rights again like trademarks. There can be any kind of derivative work that you can bring out of it. It comes into effect immediately. For example, J.K. Rowling wrote that book. It came into effect immediately as she wrote it. Lastly, you can use, reproduce, and reuse that work. What can be copyrighted? Literary works can be copyrighted. Novels, non-fiction, poems, articles, essays, speeches, catalogs, anything. Now, there are different speeches of Abraham Lincoln that are very famous, speeches of Jawaharlal Nehru that are very famous. Those can also be copyrighted. Musical works, a new song comes up, falls into the category of copyright. Dramatic works, operas, plays, screenplays, music, pictorial, graphic, or sculptural works, they can also be copyrighted. Engineering drawing maps, charts, globes, sculptures. Now, sound recordings, again, just like music, and different kind of compilations for that matter can also be copyrighted. What is the duration of a copyright? For literary, dramatic, musical, and artistic works, it is 60 years, sorry, from the beginning of calendar year, next the following year in which the author dies. For example, a person is, I am the author of a work. I die in 2025. Now, starting from 2026, 60 years from 2026, I'm going to hold the right over it. Now, for cinematic works, sound records, government work, public undertakings, it starts from 60 years from which the year has been published. Okay. Now, coming on to the topic of AI, how is copyright and AI related? Now, what is happening is, you all know about ChatGPT, we all know about OpenAI, right? We, in fact, have used it someday or the other. Now, machine learning is something that you enter a data into a machine, the machine goes through that whole compilation of records, and then it gives you an output that has been concluded from that particular set of records that it has taken into account. Now, what machine is doing is, it is taking its independent decisions. That piece of work is generated by the computer program itself. Now, who is going to have the rights over it? What is the example? Google is actually funding an international an artificial intelligence program, in which it is the artificial intelligence machine is going to write local news articles. Now, see how easy it is. You are just taking data from the local news reports, local news networks, and then Google is going to take that data and put it into a computer program. That computer program is going to conclude everything and bring out a new article that has all the pointers that different news reports actually had to go on the place and collect it from. Now, what Google is doing, it is doing nothing but collecting data from the things that are already available on the internet. Who is going to have the rights over it? Can you get the copyright over such news articles? No, you cannot. AI did it, not a person did it, no individual did it. Okay. Now, there's also example of a short novel that some Japanese students undertook. They gave some data to AI. The AI generated program wrote a novel. They entered it into a contest. Now, the contest did not know, the judges did not know that the novel is actually produced by what? An AI program. And the novel was actually able to reach the second round of that contest. So, how bewildering that is, right? It is taking over everything. What is going to happen to the authors that are actually putting their minds to it? What is happening going to happen to authors like J.K. Rowling? They are putting their minds, their efforts, their lifetime into writing something like so unique, right? Now, there are AI programs that are going to generate music. Now, how does this become difficult? Now, there are people like Arijit Singh, now Sonu Nigam, Alka Yagnik, Lata Mangeshkar, lyricists like Javed Akhtar. They had that knack of writing songs, of writing lyrics and singing it in a way that it appeals to the public, right? What is AI going to do? AI is actually going to study the whole public, because they have access to our data, which has been proved in multiple court proceedings, research papers, news scandals. It comes out every day that people have access to our data. Now, AI is going to study the taste that people have of this particular age. They are going to study the music notes, the lyrics that different artists are putting their effort into, and then they're going to produce a piece of work that aligns with that particular taste. Now, they did not have to be Javed Akhtar, they did not have to be Arijit Singh, Alka Yagnik, or Lata Mangeshkar to do that. They just had to input a data, and the result was what? A hit in the market. Because why? They have already studied the taste that people like. Again, the problem comes with, I've already discussed the authorship and ownership. What is the duration going to be? As I discussed, it starts for literary works. Example, it starts the next year from the death of that author and lasts for 60 years. Now, something that is being created by AI, what is the duration going to be? How do we know? We don't know that. there are recent copyright disputes that have happened in India. For example, there was a company, Simply Life India, that was using some impersonations of Anil Kapoor, and Anil Kapoor was doing different things, and Anil Kapoor did not authorize that person to use his image, his photograph, his body language, but they did use so. But the court injuncted the other person from using Kapoor's personality, rights was infringement of privacy, of course. Similarly, a person was using Barbie's images, and next a person created a program, Raghav, and the sole author of the person in the form that you have to fill for copyright, the sole author was mentioned as Raghav. That is the AI system that the person created. The copyright office actually accepted it, but then later they had to withdraw it because it's an AI system, not an individual person. AI can also help, for that matter, in recognizing copyrights. The bigger example can be Instagram, or let's say YouTube. You upload, a lot of people are aspiring YouTubers, I know, these days. Maybe somebody in the audience is also a YouTube aspirant, an influencer to be in the future. Now what happens is, people know that when we upload a video on YouTube has some guidelines that it has to be unique, it has to be new. You can't just copy paste somebody else's video and claim rights over it, claim money from YouTube for it. Now, what is YouTube doing? YouTube is using AI to recognize the copyright rights of other people in that particular work, and then taking out the videos and taking down the videos that the other people are using that are infringing in nature. So that is how AI can be used in a better format. Lastly, we are going to discuss is design. Now, what is a design? It is the outer outlook of an article that a naked eye can see, right? A shape, configuration, pattern, ornament. Example can be, Bulgari is a jewelry what brand. They make different kind of jewelries. There's this particular snake jewelry by the name of Serpenti. You must have seen a lot of people wearing bracelets, necklaces, rings that has a snake on it. Bulgari has a design registration for it. They thought of that design in 1960s, 70s, and they got it registered. So nobody else can make an ornament that has the design of a snake by the name, even if you're not using the name Serpenti. But if you're using the design of a snake, then it is already registered under Design Act by Bulgari, and nobody else can use it. Agricultural instruments, for example, this is a dehusking coconut implement. It is a design. Robot for sowing seeds, a frog shaped drone for agricultural monitoring. That is a particular design that is registered and nobody else can use it. That is all for today. I think I've already surpassed 5 minutes of my time. So thank you so much for having me here. This is my email ID that you can see on the screen. Due to paucity of time, I don't think I'll be able to take up questions right now. But you can reach out to me on kriti.pathak@unitedandunited.com, and I'll for sure be available. I'll give you detailed responses for everything. And I'm going to hand over the stage to, thank you so much for having me here, ICAR. I'm going to hand over this session to Dr. Shivangi Jori, who is going to handle the patent section of that IPR and AI part. So over to Shivangi, ma'am. Thank you so much for everybody having me here. Thank you so much.
Thank you very much, Pathak ma'am. Now I invite Dr. Shivani Johari.
Hello?
Yes, ma'am. Audible, ma'am.
Yes, ma'am. Okay. Am I audible, ma'am?
Yes, ma'am.
Okay, ma'am.
Yes, audible.
Good morning, everyone. First of all, thank you so much for giving me such an opportunity to present, to deliver a lecture before the ICR. Today, my topic is regarding innovation and artificial intelligence and innovation. So here I'm starting my slides. This is what is. I hope my screen is visible, ma'am.
Yes, ma'am. Visible.
Okay, okay. Thank you, ma'am. So this is the patent certificate that is looks like after grant of the patent office issue us a patent certificate where the name of the patent number, application number, the name of the patentee is visible along with the title of the invention. So this is the patent certificate that is looks like. Now, first of all, I would like to, I think all of you are mostly aware about the patent, but still in just short, I just want to tell that what is patent. So patent is actually an exclusive right that is granted to the owner of the patent. It is also beneficial to the public because the patented invention also gives the technical information to the about the invention to the public. Further, what is so this is the regarding the patent. Patent is given to the invention. So what is the invention? Invention either can be a process or a product. So for both the process and product, there should be a new way for doing something or offer a new technical solution to the existing problem. This is the invention. So by patenting an invention, the patent owner gets exclusive right over the patented invention. And the patented invention is granted for a 20 years of after the grant of the patent, after the expiry of the 20 years, the patent become has the once the period of protection has come to an end, the invention become off patent, meaning anyone is free to make the patent. Now, here is the industry and patentable component. This is the agriculture where the composition, where the component, machinery, fertilizer, farm food, processing, chemical composition can be patentable. In the area of biotech, vaccine, therapeutics, diagnostic kit, biofertilizer, biopesticides, chemicals, basic chemicals, polymer, petrochemicals, consumers, foods, food processing method, recipe, formulation, health supplement. These can be patentable under the Indian Patent Act. Pharmaceuticals, new drugs, composition, formulation, doses. Now, why protect invention with patents? Suppose you have a invention and somebody already using this invention without your consent. So when you get a patent, you have an exclusive right to stop that person from using, selling, making the patented product. Either it is a method or a process, it is a product or a process. While granting your patent, you have a right that you can also go to the court to seek remedies to patent infringement. Again, how to protect invention through patent? To obtain a patent, we have to file a patent application where your invention is described and it is filed along with the Indian Patent Office. Further, the patent can also be filed in multiple countries depending on the business and financial resources of the patentee. So what are the criteria of the patentability? An invention is patentable subject matter if it meets the following criteria. It should be novel, it should be inventive, it should be industrially capable, and it should not attract the provision of Section 3 and 4 of the Indian Patent Act. So here it is novelty. What is novelty? Novelty means new. It is not anticipated by prior publication in patent or any non-patent literature. Novelty shows the difference between the invention and the discovery. Invention is considered novel if it is not anticipated by prior use or prior knowledge in India. It is considered as anticipating novelty if all the features of the invention under examination are present in the cited prior art documents. What is inventive step? Inventive step, the invention should be inventive. The invention technically advanced in the existing knowledge or having economic significance or both. So it should have technically advanced to the already existing existing technology and economically significance or both. Industrial applicability, the invention can be made or used in an industry, so it can be patentable. Now, what cannot be patentable? Section 3 of the Indian Patent Act has some criteria, has some subsections that gives that few are the invention that cannot be patentable. They are subsections from Section A to Section P, and under Section 4, there is an Atomic Energy Act, where I will come forward later. This is Section 3A. What is not patentable? An invention which is frivolous, which claim anything contrary to well-established natural laws. But here the example is perpetuation machine contradict law of conservation of energy. So this invention, this machine cannot be patentable according to Section 3A because it is frivolous and it is contrary to well-established natural law. Here Section 3B, harmful to life. An invention to the primary or intended use, commercial exploitation of which could be public mortality, human, animal, plant life or health or to the environment. Example is copying machine in the exam, biological warfare material, weapons of mass destruction. Next is Section 3C, scientific principles. The mere discovery of scientific principle, formulation, abstract theory, discovering of living or non-living substance cannot be patentable. Scientific principles are not considered. However, a process based on the use of the scientific principle that giving a new result, so it can be considered as a patentable invention. Next, finding of substance or microorganism occurring in nature is a discovery, and this is not an invention, so it is also not patentable under Section 3C of the Indian Patent Act. Section 3D, new use of known substance. There are few parts of Section 3D that states that the mere discovery of a new form of known substance is not patentable. The substance of the mere discovery of the new property or new use of a known substance is not patentable, or mere use of a known process, unless such process result in a new product, is not patentable. So in this case, to overcome the objection under Section 3D, the complete specification should bring out how the claimed subject matter is in term of enhanced efficacy is giving the better result as compared to the already existing compound or already existing invention. There is a landmark decision in 2013, Novartis versus Union of India. Novartis was in a case, the Supreme Court of the India upheld rejection of patent application filed by Novartis for Glavik 400 mg. This is the anti-cancer drugs that is a new crystalline form of imatinib mesylate. So the court ruled that new form of the already existing substance do not demonstrate the enhanced efficacy. So compared to the existing form, so it does not qualify the criteria of the Section 3D and it is not patentable. Section 3, mere admixture, a substance obtained by mere admixture that is resulting in the aggregation of the property of the component or a process of producing such component is not patentable. However, a mere admixture resulting in the aggregation of the property and in giving is a synergistic effect, then it can be considered as a patentable subject matter. Again, synergistic effect of the claim composition should always be greater than the sum of the individual component. Then it should be considered as a patentable subject matter. The complete specification should be provided a detailed comparison, a detailed data regarding how the claim composition is giving the enhanced effect in terms of their other already existing composition. Next is section 3F, mere arrangement, rearrangement, or duplication of known device. Each work independently is not patentable. Here, this is the chopping stick where a fan is attached with this stick. So this patent is not patentable. This invention is not patentable because this is a mere arrangement or rearrangement of devices. This is a mere juxtaposition of a known devices with that work independently is not patentable. However, all integer placed together having working interaction with each other and giving a new result can be patentable under section can be patentable under Indian Patent Act. Next, section 3H, a method of agriculture or horticulture is not patentable, like crop rotation, grafting, new plant varieties, method of cultivation of algae, method of removal of weeds. So the new plant varieties come under Plant Varieties and Acts. So these varieties are registered under those acts. Next is section 3, treatment of human being. Any process or medical, surgical, curative, prophylactic, other treatment of human being, process of similar treatment of animal to render them free of disease or to increase their economic value is not patentable. So this provision excludes the following from patentability: medicinal method, process of administering medicinal orally or through injectable, surgical method, a stitch-free incision for contract removal, curative method, a method of cleaning plaque for teeth, prophylactic method, a method of vaccination, therapeutic method, the term therapy include prevention of adverse treatment or cure of disease. So this provision excludes the provision from the patentability. Next is section 3J, plant animal as a whole. Plant and animal in whole or any part thereof cannot be patentable, including seeds, variety, species, biological process, production or propagation of plant and animal. However, genetically modified microorganism can be patentable, subject to other requirement of the patentability. Section 3K, a mathematical or business method or a computer program per se or algorithm. This is not patentable. For AI-related invention, it must satisfy the essential legal condition of novelty, inventive step, and industrial applicability like any other invention. And computer program as such are not patentable under section 3K of the Indian Patent Act. So as our topic was innovation and AI, so how AI and why AI can be protected under the Patent Act. So for computer related invention, there is a detailed guideline, that is a CRI guideline, which state it is only when contribution to an invention solely lies in the computer program per se or business method, a mathematical method, the claimed invention cannot be allowed for falling under section 3K of the Act. If we are using a software, then this software is as such is not patented. However, if it is connected with a hardware like a system, computer or laptop, then it can be patented. Here is some Indian patent application that is granted, that is on the under section granted for artificial intelligence based assessment for AI related invention, that is artificial intelligence based assessment and tutoring system and method thereof. Tutoring system and method thereof. There is an Indian patent application, another Indian patent application, that is a artificial intelligence enabled automated system for targeted content or display device, was granted upon demonstration of technical advancement in solving the issue related to the conventional system by using classification. Scene understanding uses deep learning architecture. So there are a few patent application, Indian patent application that is granted by the patent office related to the AI inventions. So it is clear that to make AI-related invention, it qualify as a patentable subject matter and avoid its fall under exclude subject matter. It is required to significantly integrate essential element feature of AI in practical aspect. Further, for patenting of AI-related invention, if the patent is for hardware, then such structural components should be disclosed in the invention. If the invention related to the method, then the necessary sequence or steps should be given in the description. If the operation of the operation of AI powered device should also be disclosed in the invention. The means plus functions claims should be avoided while drafting the claims for patented for computer related inventions. So this is regarding the section 3K. If any invention about AI show technical advancement and is carried out by a structural component, it should be considered patentable subject matter. So there are a few guidelines that also should be considered while rejecting the patent application under section 3K of the Indian Patent Act. This is section 3I, artistic work, writing, music, work of fine arts, painting, sculpture, these are not patentable. And it says, the section 3I says literally dramatic, musical, artistic work, aesthetic creation, including cinematographic work and television productions. These are not patentable. Section 3M, mere scheme, rule, game, a method of playing game, a method of performing mental act, method of playing chess, method of solving crossword puzzles, method of teaching, it is also not patentable. Section 3N is straight presentation of information, PowerPoint presentation, research paper, graphs, these should not be considered, should be avoided while drafting the patent application. Section 3O, topography of integrated circuit. So this is the circuit board. So this circuit board is also not patentable under section 3O of the Patent Act. However, semiconductor integrated circuit layout design of Act is provided for registration of topography of integrated circuits. So here we can register our invention through this Act, Semiconductor Layout Design Act. This is traditional knowledge. An invention which is in effect is traditional knowledge or which is in aggregation or duplication of known properties is not patentable. The best example is turmeric, the anti-healing property of the turmeric, and the neem, the insecticidal property of the neem. It is also not patentable, as it is not patentable. Section 4. Invention relating to atomic energy. So no patent is granted in respect of the invention that relates to the atomic energy, falling under subsection 1 of section 20 of Atomic Energy Act. Further, if something has been filed or something has been filed by the inventor, that is the invention related to the defense purpose, then in that case, the controller, upon screening the application, gives forward this application to the central government to review the application and give their inputs regarding the invention, that either it belongs to the defense purpose or not. Who can apply for a patent? So a patent application can be filed either by a true and first inventor or as a signee, either alone or jointly, or any other person. A legal representative of the deceased person can file a patent application. How can apply for a patent? A patent application can be filed with Indian Patent Office either with provisional specification and complete specification. If the provisional specification has been filed, then we have a 12-month period to file the complete specification. When should an application for a patent be filed? So when your invention is in idea phase, or it is a patent can be earliest possible date and should not be delayed. An application filed with provisional specification disclosing the essence of the nature of the invention help to register the priority of the application. So if you just want to save your priority of the invention, then you should at least file the provisional specification to save the priority of the invention. Can any invention be patented after publication or display in the public exhibition? If suppose you have display your invention in some scientific workshop or any other seminar, or before any government officer, any government organization, you have presented your work or research, so in that case patent office give us 12 months grace period, so that in that 12 months we can file our patent application, so that our invention can be protected after filing the application. Type of specification: provisional and complete specification. Provisional specification is when reached at a stage where it can be disclosed on paper but has not attained the final stage. Like if you have presented your theory or something invention, but it is the experiment or result has not been come out, you are awaiting for your result and the research has reached at its stage, so in that case we can file a provisional specification. So if the provisional specification contain where the urgency, commercial disclosure, submission of thesis, inventor leaving the organization, mean many competitor, and accidental disclosure. So in that case, we can file provisional specification. After there is the content of the provisional specification: title, field of the invention, background of the invention, object, statement, claims. Claims are not included in the provisional specification. Further, there is a advice that include as much as information as the applicant has at the time of the filing of the application. So whatever the knowledge about the invention is known to the inventor should be incorporated in the specification. A complete specification, it fully and particularly describe the invention and disclose the best method of performing the invention, end with the set of claims, and it should include the drawing and an abstract. If the complete specification discloses a biological material, then it should be submitted into the depository authority. If and no ambiguity while drafting should be shown. So the content of the specification: title, field, background of the invention, objective of the invention. Title is the title of your invention that disclose the that tell about the invention. Field of the invention is talks about the in which field the application falls. Background is regarding the conventional problems, already known problems that was existed, and how the invention is overcoming the existing problems. Object of the invention regarding this, what is the objective of the invention, how your invention is giving result, how it is effective. So it gives about the object. Summary of invention: this is the summary, like what is your invention in few words. The summary should be included. Brief description of drawings is included, what are drawings are saying, and it should be numbered, and no descriptive matter should be included in the drawings. Reference number should be included in the drawings. Claims and abstract. Abstract is the crux of the invention that's talked about the invention. So here is sufficiency of disclosure. Description: discuss the invention, full scientific details of the invention. Claims are, as you can say, heart of the invention, and define boundary of monopoly. So the invention shall be described fully and particularly to satisfy what requirement, and further the best method of performing the invention. Discussion must be unambiguous, clear, correct, and accurate. And no descriptive matter should be included or avoided that mislead the person skilled in the art to whom the specification is addressed. what is fully and particularly. Fully, if the system led to apparatus, that is hardware based invention, each and every feature of the invention should be described with illustrative drawings. However, if the method is given, then the step-by-step method in a sequence should be included in the descriptions. The working relationship of the different component together, it should be disclosed in the description. The output of the invention should be disclosed. If the invention discloses a composition, then a synergistic effect by way of table, by giving a comparative example, should be disclosed. If it is a component compound, it is a method, then compound is disclosing, then it should show a enhanced efficacy in compared to already existing compound. And if the method is given, then the method steps and which steps is new, it should be given in the description of the invention. Best method of operation. The best method of operation and use of the invention shall be described with suitable illustration. The specification should not limit the description of the invention only to its functionality. Rather, it should specifically and clearly describe the implementation of the invention. Title should be sufficiently disclose the subject matter of the invention. It could be product or process. As I said, background talks about the conventional method and drawback of the already existing knowledge. So this is the drafting. That was the drafting of the invention. So anything else? I am ending my slides here.
Thank you very much, ma'am.
Thank you, ma'am.
Both Pathak and Dr. Shivangi Johari, though because every year on this one World Intellectual Property, some other way awareness being given on IPRs, but today and every section, well, patentable, non-patentable, very in-depth presentation. Thank you very much, and also we are dealing with for filing many IPRs. And from today's presentation also, it has come to we should go for trademark for our CARI logo. That's what today also it has come to our mind. Thank you very much, ma'am, for that intuition. I request all the online participants and from our CARI side also, if you have any doubt regarding any IPRs, then you can ask 1 or 2 questions. Otherwise, ma'am.
Yes, sir.
Online participants. In that case, ma'am, okay, ma'am, we will write to you.
Sure, ma'am. Here is my email address and my phone number.
But from my side at this platform, I take this opportunity to look for all the pending cases. 1 or 2 cases are very still long pending. For example, this polybag. Yeah,
Sir,
layer.
ma'am, you can write us an email and the application number. We will look.
Every week reminder is being given on that, and so please look into this, ma'am.
Yeah, ma'am. Ma'am, please mail us.
Yes,
we
yes.
will look into the matter.
Yes, ma'am. And thank you very much, ma'am. Thank you for your presentations, and thank all the online participants also for your interest to take part of this program. And I thank all the scientists and the project staffs and students of CARI also. And finally, I very much thankful to our director also for giving this opportunity to conduct the same. Thank you very much. Thank you, one and all.
Thank you, ma'am.